All right, you're Rebecca Rideau, and will your client waive a formal reading of the indictment in each? All right, in this case, which is 23 DCCR 0928, you're charged with a state jail felony offense of theft of property with previous convictions from November 21st, 2022. The indictment alleges you were previously convicted of theft September 11th, 2010, September 17th, 2010, in two different cases. And then again, October 26th, 2015, and then September 21st of 2021 in three cases on that date. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are all those prior offenses and convictions true? And then finally, in cause number 24 DCCR 1925, you're also charged with a state jail felony offense of theft of property with previous convictions. This is from June 13th of 2024. It alleges the same prior convictions of theft. How do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you actually did what they've charged you with. In each of those four cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson? And do you fully understand them? And it's my understanding you have no agreement in your case, in any of these four cases, and so you're just pleading open to me. Is that correct? I want to make sure you understand your cases are set for trial. To begin with jury selection next week, you have an absolute right to have a jury come in and decide if you're guilty or not, and then to decide what the punishment is if they find you guilty. If we go forward this way, you're leaving that up to me, and is that what you want to do?
This is huge. The prosecution wants to stack the sentences. That means instead of serving time at once, Rebecca could face back-to-back prison terms. Imagine the difference between 2 years total versus 2 years multiplied by 4. That's the kind of move that changes everything.
Okay. They're all different offenses, correct? Or at least, yeah, I think they are. Nope, they're all different offense dates. And have you gone over that with your client?
Yes, Your Honor, she's aware of this from the charges.
I guess part of my issue with this, that say I do something that Ms. Rideau doesn't like, and then she has the ability to appeal, and I don't know if it's really an appealable matter, but you never know. I don't want to waste a bunch of time and then us be coming right back here. But
You have listened to
no, I don't disagree. Well, we'll get where we'll get. All right, so you understand that I can give you anything from probation up to 24 months to 2 years on each of these cases. And I can stack those sentences on top of each other. You understand that as well. And you want to go forward with these pleas and get the sentencing on these done, correct?
In addition, Your Honor, my client, I know the response to the court gave me prior answer, but I am required to ask the court. She's asking court waive treatment investigation on these and proceeding sentencing. She also would like to release her pleas.
The defense tried asking for leniency, even a temporary release for a graduation cap, but the judge shuts it down immediately. Why? Because Rebecca's criminal history is stacked. Judges want every detail before handing down a sentence.
Daughter's graduation.
No, that's not happening. All right. And I'm definitely not going to waive the pre-sentence report because I want to make sure that it's just the ones, if there's any other history. Obviously, there's a substantial amount of history, and so I want all of the information. So we will get a pre-sentence report done in all of the cases, and I'm not doing anything with the bar other than potentially raising it to make sure that we're where we need to be when we need to be. So, That being said, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each of those cases.
No objection.
If admitted in each of those cases, is there any evidence Ms. Rideau is not competent? Right, ma'am, I'm going to find that you entered your pleas of guilty and true in each of these cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. In each case, I'm going to find sufficient evidence to find you guilty. However, I'm going to restate your cases, sentencing, so that the probation department can do a pre-sentence report. That will give me more information about you for cases, and then we will come back at a later date for sentencing. And then I will number the tampering case for trial next week. Obviously, it's fairly new compared to some of the other ones, but it looks like a lot of them are getting taken care of this morning, so you never know. You guys will know today after docket what the trial order is.
One final thing, on the chamber, the styles through the meeting, I'll probably noted, all that.
Look, we're not. This isn't a conversation. It doesn't matter, and they didn't put anything on you. Okay, listen. That's what juries are for. If you don't, Mr. Wilkerson has gone over it, I'm sure, with you. He has his position legally. You know what the options and what the consequences are in that case. In that case, if you go to trial and you're found guilty, and there is a prior robbery conviction, it's important that you understand that the range of punishment then becomes that of the second-degree felony, which is between 2 years and 20 years. Do you understand? Okay. And so I will number that case for trial for next week. All right? You can go back with the bailiff.
Thank you.
Thank you. I'll let y'all know as soon as docket's done what the trial order is.
Thank you.
Yes, sir. In cause number 25 DCCR 0270, charged with the third-degree felony offense of obstruction or retaliation from January 29th, 2025. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Now comes the second case. The state offers the minimum 2 years in prison. But here's the tension. The defendant claims he was set up, even referencing video evidence. Thinking face, this is the classic dilemma. Do you take the plea deal for guaranteed time, or risk a trial and possibly face way more?
And what is the offer that's been made?
2 years. Judge.
And so, the state has offered, if you want to enter a plea of guilty, a 2-year term in prison, which is the minimum. You have every right to reject that and have your case for trial, but I want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial, or do you want to take that offer? Sure. So that's what a jury's for. If you don't think you're guilty of what they said, then I don't need to know that. That's what a jury's for. Either you accept the plea agreement because you're guilty, and if you watch the information with your attorney, then you've seen everything the state has, and they'll present, and we can let a jury decide. I just want to make sure you understand what the consequences are and what your options are. Do you understand all of that? So,
I'll explain this to them. I've shown you several videos. Some of them are more relevant than others, and things. There may be other videos out there that I don't know about. They're not there part of discovery. As indicated, we wanted to hire Marcia Norman, and I told him you can reject if you're not guilty, then you don't plead guilty and can reject it. Well, you can still hire Marcia in the meantime.
Mr. Nichols, is there any other discovery that you anticipate? Okay. Okay. So, Mr. Martin, if you don't want to accept that offer and you want to plead not guilty, I need you to sign the plea bargain rejection so that I know that you and I have had this conversation.
I want to ask I've been trying to do this job and work. Feel like, you still can help me out with my plan, like, just.
Okay, none of that matters right now, okay? Because here's what we're not going to do. We're not going to put your case on the trial docket so that you think you can get some time under your belt, and then you're going to plead guilty later. Because after today,
The judge draws the line. Balance scale, she won't let the system be used for stalling tactics. It's simple. Plead guilty and accept the deal, or go to trial and face the jury. No middle ground.
I won't accept this plea agreement. We don't put cases on the trial docket just to buy some time. Either you did it or you didn't do it. And if you didn't do it, then you can sign that and we'll get a jury to decide. But I don't want you to think you're going to come back in here later and say, oh, I want to take that deal. Because it's not going to happen. All right?
Like, I'm doing for parole.
I don't know when you're eligible for parole. I don't know how much time you have.
You know what to do. That's why
I know, and that's why Mr. Parker's,
yeah.
nobody knows when for sure you would become eligible for parole or if you would make your parole. We don't know that because that depends on other people, not. I don't make that decision. Your attorney can't tell you that. He doesn't know. It just depends on.
Explain to him how much time, based on what he told me he has, and how much time I think he'll have to do before he's eligible. And again, I told him I can't guarantee that. And again, if you're not guilty, you don't back.
So it sounds like Mr. Parker's explained all this to you. So either you don't want to take the deal, you are not guilty, and let's go to trial, or you plead guilty and sign what? You can't say you're not guilty and then sign some time. It doesn't work that way. Because what happens, for obstruction, it's not assault on an officer. It's obstruction or retaliation, which is different. And there are different elements of that offense than assault on a police officer. So Mr. Parker has gone over that with you. If you want him to explain it again, what specifically that is before, but you cannot come up here and say I'm guilty of something, or I'm not guilty, but I want to take the deal. If you didn't do it, you go to trial. If you did it, okay, sign that for me, rejecting that plea offer. Look, sir, pay attention. Sign that. So real quick, hold on before you go back. Mr. Parker has been appointed to represent you. With your permission, he handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who can begin preparation for trial a little quicker. Is that okay with you? All right, so I'm going to appoint a new attorney today. They'll be out to see you very soon. Huh? No, you're going to get whoever's next on our list. If you have whoever's next on the list. You can hire, if you have the funds to hire someone or your family wants to hire someone, they can do that. Otherwise, I'm appointing someone today so they can start getting ready, okay? All right, you can go back with the paper.